Hello, everyone. My name is Christophe Paulussen, and I'm a senior researcher at the Asser Institute in The Hague, as well as a research fellow at the International Center for Counterterrorism, The Hague, or ICCT. And also on behalf of the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, I would like to virtually welcome you to our new webinar entitled Using Battlefield Evidence in the Fight Against Terrorism, International Law Dimensions. Now, on the battlefield, a lot of information and material can be gathered. One could think of unexploded IEDs, improvised explosive devices, and components of exploded IEDs, but also USB sticks with digital information, or old-fashioned folders with paper documents, such as registration forms. And it's often military personnel who may stumble across such information, especially in the immediate aftermath of hostilities. Now, in that case, one could also speak of military evidence, although that term is not necessarily linked to the battlefield and may also encompass the securing of evidence by the military in situations outside of an armed conflict. Now, returning to the battlefield, not only military personnel may stumble across such information, but one could also think of other actors present in this context, especially after active hostilities, such as NGOs working in the field or representatives of international tribunals, monitoring and investigating international humanitarian law and human rights law violations by the parties involved in the conflict. Now, although ICCT, and I would like to mention in particular the name of my colleague Dr. Bibi van Ginkel in this context, has published on this topic as early as 2015, the subject of battlefield evidence has recently received increased attention. And the reason for this is the law enforcement potential of battlefield evidence in the counterterrorism context. Indeed, it can be used as evidence in court against terrorism suspects, such as foreign terrorist fighters, or FTFs, active in Syria and Iraq. And this is obviously something of interest to states, as they struggle to find evidence in these kinds of situations and are often only able to prosecute an FTF for membership of a terrorist organization rather than for his or her actual crimes. And also in Eurojust's report on this matter from September 2020, one can read, and I quote, "Several respondents confirmed that battlefield evidence had been successfully used in criminal proceedings and provided judgments or case examples." At the same time, the notion of battlefield evidence evokes a number of often very fundamental questions, such as whether the actors I mentioned earlier should be involved in such evidence gathering in the first place, whether they, if the decision is made that they should indeed, are sufficiently equipped to fulfill such tasks, and what can be learned also from earlier experiences where, for example, the military has been involved in law enforcement tasks, such as in the context of countering piracy. Moreover, and this will be the focus of this webinar, there are various international law questions that need to be answered. For example, what are the legal frameworks in place for evidence gathering on the battlefield to begin with? How can human rights violations by, for example, the military be avoided? Will judges accept evidence secured by non-traditional law enforcement actors? What are the implications of battlefield evidence for a suspect's right to a fair trial? Can a suspect, for example, sufficiently challenge the evidence secured by military personnel? Now, to discuss these and other matters, I'm very proud to present an excellent panel to you. And our first speaker is Professor Fionnuala Ní Oileáin, and she is the Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism since the 1st of August 2017. And in this capacity, she works closely with states and United Nations entities to advance human rights protections in some of the most difficult contexts globally. She was re-elected by states for a further 3-year term in 2020, and she's a University Regents Professor at the University of Minnesota, holder of the Robina Chair in Law, Public Policy and Society, and Faculty Director of the Human Rights Center at the University of Minnesota Law School. She's concurrently a Professor of Law at the Queen's University of Belfast School of Law. Professor Ní Oileáin is the recipient of numerous academic awards and honors, and her teaching and research interests are in the fields of international law, human rights law, national security law, transitional justice, and feminist legal theory. And moreover, she has been nominated twice, in 2004 and 2007, by the Irish government to the European Court of Human Rights, and the first woman and the first academic lawyer to be thus nominated. And Professor Ní Oileáin will kick off the panel highlighting the importance of respecting the right to a fair trial in the context of the prosecution of foreign fighters and challenges raised by the use of battlefield evidence in this context. as well as more generally the risks posed by these emerging matrices on respect for human rights within, but also outside the security context. And she will also address the human rights dimensions of access to evidence and the equality of arms in legal proceedings where terrorism or related offenses are being charged. Our second speaker is Dr. David Sharia. He is Chief of Branch at the United Nations Security Council Counterterrorism Executive Directorate, or CTED. And Dr. Sharia is in charge of counterterrorism policy and heads a large group of international counterterrorism experts, monitoring states' implementation of counterterrorism measures and advising the Security Council Counterterrorism Committee on counterterrorism matters. The branch, under his leadership, covers all areas of counterterrorism policy, including legal and criminal justice responses, financing of terrorism, law enforcement and border control, gender dimension of counterterrorism, terrorist use of technologies and the internet, human rights, and CVE. And Dr. Sharia is an internationally recognized expert on counterterrorism, and his articles and books have been published by Oxford University Press, Harvard National Security Journal, and Hebrew University Press. And recently he was invited to serve as a national security scholar in residence at Columbia Law School and a fellow at NUI Center for Global Affairs. Dr. Sharia will explain the scope of the CTED guidelines to facilitate the use and admissibility as evidence in national criminal courts of information collected, handled, preserved, and shared by the military to prosecute terrorist offenses, also called the Military Evidence Guidelines. And as explained before, these guidelines address military evidence and are thus a bit broader in scope than battlefield evidence, at least as regards the place where the evidence is secured. But given the considerable overlap, they are still very relevant for our discussion. After that, we will turn to Professor Noam Lubell. He is a professor in the School of Law, University of Essex, and director of the Essex Armed Conflict and Crisis Hub. And he was head of the law school from January 2014 until January 2017. And Professor Lubell held the Swiss Chair of International Humanitarian Law at the Geneva Academy from 2013 to 2019. And from 2010 to 2018, he was the rapporteur of the International Law Association's Committee on the Use of Force. During his research leave in 2017 and 2018, Professor Lubell was a visiting scholar at the Johns Hopkins University Applied Physics Laboratory in the USA. And in addition to his academic work, he has worked for human rights NGOs in the field and has provided consultancies and training in the laws of armed conflict for NGOs, governments, militaries, and the media. He has been a member of numerous expert groups and consultations with governments, the ICRC, and the UN, including on military uses of cyber operations and artificial intelligence. Professor Lubell is the author of the book Extraterritorial Force Against Non-State Actors, published by Oxford University Press, and he's the co-author of the recent ICRC and Geneva Academy guidelines on investigating violations of international humanitarian law. And it's these latter guidelines that we would like to address them in further detail. Indeed, what is the relevance of these guidelines to the topic of this webinar and the use of battlefield evidence in the fight against terrorism? And what does international law say about investigations, including the collection of evidence on the battlefield and, if possible, its use in court? And our final speaker will be Ms. Maya Foa. She's the Joint Executive Director of the international legal NGO Reprieve, and she leads a team of lawyers, investigators, and campaigners fighting against grave human rights abuses, including in particular in the context of terrorism. And Reprieve has been at the forefront of the fight against abuses in counterterrorism post 9/11, working on torture and extraordinary renditions, indefinite detention in Guantanamo Bay, the use of lethal drones in areas of non-armed conflict, capital terrorism prosecutions in Iraq, and most recently, the detention without charge of trial of men, women, and children in camps and prisons in northeast Syria. And Ms. Foa has been working with detainees in Syria for a number of years and has visited the camps on several occasions. And she will speak about the concerns that her organization and others have about battlefield evidence, the impact on fair trial rights, and more broadly, the troubling politicization of legal processes in the context of the fight against Daesh. Now, thanks to all of you for being with us here today. And as agreed, and for ease of communication, we will use first names for the remainder of this webinar. And after the presentations, there will be some time for Q&A with you, the audience watching from home. So please send in your questions using the chat function, which you will see at the bottom of your screen. Now, I've already spoken enough, so without further ado, I would like to give the floor, or better the screen, to our first speaker, Fionnuala. Thank you again for being with us, and you have the floor/the screen. Thank you.
Thank you all, and happy St. Patrick's Day to everyone. We hold this event on a big celebration, or a rather subdued celebration in Ireland today, as we're all still at home. But nonetheless, happy St. Patrick's Day to all. So I'm really grateful to the Asser Institute and to Christophe for, on behalf of the mandate, to be willing to co-host this event with us. And my legal team, Dr. Anne Cherbourg, and I have been working with you for many weeks to bring this together, and we're really pleased to be holding this event. Also want to thank our other panelists, Dr. David Sharia from UNCTED, with whom the mandate has an ongoing deep and sustained engagement and positive dialogue on so many of these issues, to an old friend, Professor Noam Lubell, who's joining us, and Maya Foa, with whom the mandate also works on many issues related to Syria, Iraq, and beyond. So let me say a little bit about the entry points for the mandate to this discussion today. Fundamentally, as many of the listeners will know, the mandate's role is to protect and promote human rights and counterterrorism more broadly. And the stress is on really trying to ensure that in the most difficult of contexts, particularly when these the impact on counterterrorism on human rights can be extensive, that we continue to press for the optimization of human rights and the rule of law. That's not just because that's the moral and right thing to do, but rather because the long-term interests, including the security interests of states, are really intimately connected with bringing those two things together, countering terrorism while upholding the rule of law and human rights standards. I think we also come to this from an understanding of the historical abuse of legal process, particularly abuses of fair trial and counterterrorism context. And it's that frame that shapes the mandate's starting point, which has a couple of dimensions. It starts really by my commitment and those of my predecessors to enabling and supporting the rights of victims of terrorism, because we believe fundamentally that fair trial and ensuring fair trial actually advances the long-term interest and redeems the rights of victims of terrorism to meaningful accountability. Related to that, of course, is the commitment to anti-impunity and to ensure accountability for serious violations of international law, which include war crimes, crimes against humanity, and genocide in particular. And finally, we think there's an independent need to speak to the preservation and value of fair trial as an essential aspect of the rule of law, not just nationally, but internationally. And that includes the notion of equality of arms between the prosecution and the defense, and the prevention of exceptionality, which I will say a little bit more about, but to note that counterterrorism has always been the space in which exceptional legal responses have been at the heart of state responses. And that exceptionality, in my view, both as an academic and as special rapporteur, has not served us well, either in the response to terrorism or in the long-term response of preserving the balances in legal process and institutions. And from that, we take the view that advancing the rule of law is absolutely essential to preservation of an adequate and functional legal system, which is integral to the prevention and regulation of terrorism. So let me say a little bit about the history of fair trial in counterterrorism. Some of this being based on my own academic work, both before and since I've become special rapporteur. In a book I wrote in 2006 called Law in Times of Crisis, I pointed out, and I think demonstrated with my co-author, that courts are a management tool for the states to manage terrorism. So historically, courts have been caught in the crosshairs of the state's responses to terrorism, and that has created numerous multifaceted and highly complex challenges for the courts and the legal profession themselves. The second point I think I would underscore is the way in which courts in particular and trial in particular, it often manifests a tension between what I would call the closed and the open state, an issue I addressed at some length in an article I wrote for the Journal of National Security Law in 2018 called Managing Terrorism. And it is that cross space where in fact the open and the closed state come into play in the courtroom, and evidence is at the heart of where the open and the closed state intersect with one another. And the third history I want to underscore is the way in which, and I've mentioned this before, the way in which courts become a tool to manage large-scale terrorism challenges. And that more often than not involves a move to exceptionality in the courts, whether it's in the form of the court themselves, here I would use the example of diplock courts in the UK, or the Special Criminal Court in the Republic of Ireland, or the use of military commissions, as we've seen in Guantanamo Bay, Cuba. And that exceptionality has far-reaching consequences for the integrity of legal systems, but also for the integrity of international human rights and humanitarian law. So it's in that background context that I offer our comments on the proliferation of standards related to battlefield evidence over the past couple of years. And I'm really grateful that David Sharia is here today to talk about the CTED guidelines, but also just want to say really clearly to the audience, this is just one of a number of guidelines or standards that are out there. That includes, for example, the non-binding guiding principles on the use of battlefield evidence in civilian criminal proceedings, which have been co-produced by the United States Department of State's Justice and Defense. We have a NATO policy on battlefield evidence. We have the Global Counterterrorism Forum, Abuja recommendations. So just to say, we've seen a proliferation of these standards. And I think from the mandate's perspective, I think of these as soft law standards, and some in the audience will be aware that I have raised a number of concerns about the push to soft law adjudication in counterterrorism more generally, a concern that in practice, some of these, quote, soft standards are viewed as hard by states, really in an attempt to sort of push aside or render irrelevant the other applicable hard standards, which would be customary international law and treaty law. So I raise that as one just overarching concern about the interrelationship of these multiple standards and guidelines to the broader terrain of trial, fair process as protected by international law. And I think the second set of questions that the mandate has asked is really who produces the norms and who's engaged in the process of standard setting or advice. And I think that has also related to broader questions that the mandate has opened up around the accessibility of that standard setting to those who are the multiple stakeholders who are the subject of those standards in practice, including domestic legal systems potentially. I do want to be clear that this conversation is important because at the heart of it, I think, is the mandate's commitment to prosecuting persons who've committed serious violations of international law. And the necessity for prosecutions of serious terrorist offenses is absolutely clear, both at the national and at the international level. But I think that what I would underscore is that we do already see a significant experience of prosecuting terrorism offenses in national legal systems of multiple kinds across a range of serious criminal acts, as well as extensive experience of prosecuting serious crimes in international and hybrid criminal tribunals. So I do want to underscore that I think in many cases, most of these cases, what we've seen is the jurisdictions functioning admirably and effectively within the rules that we have, particularly those rules on the admissibility and standards of proof for the use of evidence. And I think I suppose the mandate would say very clearly that it concerns us that we see a shift away from or a move to perhaps weaken or undermine those existing standards, or to be unclear about the relationship between those existing standards and new softer law standards. It, I think, is also clear to many of us that the use, particularly of the terminology of battlefield evidence, is being pressed into the response that we see to the urgent needs in Iraq and Syria because of a deficit of legal accountability in that context, which is clear. And so it is concerned, we have to not ignore that political context and to be aware that we're seeing a push for the admissibility of evidence, which may not be currently lawful under either national or international law, partly because the push to construct extraordinary and exceptional rules of admissibility, I think are premised in part on an undefined caseload that is not fully clear either to the mandate or other observers. And so I think here we have to have a real and meaningful conversation about what the actual caseload involved will be and what the balance in the integrity of existing rules is against the creation or expansion of new rules of admissibility of evidence that may in fact undermine and create exceptional spaces within national legal systems. Let me close by saying I think there are some really clear risks to fair trial in this context, and I know this is something Maya Foa will likely speak about. I do have concerns about the abandonment abandonment of specific requirements in Anglo-American common law systems, for example, that prohibit rules on hearsay or comparable rules in civil law systems. I think we have a concern that the reliance on military actors whose training and experience may be inconsistent with law enforcement training and whose knowledge or methods in bringing complex criminal cases through national criminal systems, that's virtually nil in practice for many militaries. And so the consequences of the importations of standards to make it easier for them, I think, raises a host of issues. I think we also would welcome the conversation about the reliance on intelligence actors whose methods and means of evidence and information gathering is often lacking independent oversight at the national level. So let me close with a couple of the highlights that we think that any use, if we were to move towards human rights compliant investigation and use of terrorism offenses with the use of new kinds of evidence, then I think we would have to have a couple of core baselines. And let me just set out a handful of them for you. The first is that the investigation and the evidence gathering should be consistent with international law and should constitute activity which has the purpose of establishing facts surrounding acts in order to determine criminal liability and or state responsibility, and not merely fishing expeditions. The second is that the collection of evidence for the use in criminal trials should generally be carried out by independent and impartial investigative authorities. And what that means is that any investigation, including the collection of evidence, has to be carried out without undue influence by authorities, even other than those who are carrying out the investigative or judicial function. I'm also fairly clear that individuals, including military or civilian personnel, have to be fully and adequately trained in human rights compliant preservation, collection, documentation, retention of evidence, particularly if that information is intended for use in civilian trials involving acts of terrorism. We also have to be clear that there are human rights compliant safeguards in securing, wherever practicable, the scene in question, documenting it with photographs, and ensuring that investigative steps are taken and meticulously taken to enable robust cross-examination of any evidence adduced at criminal trial. Two final things. Evidence collection should also always include the active collection of exculpatory evidence, which can be used in any trial process to assist in the determination of guilt or innocence of the person charged. And finally, it seems to me critical to underscore that trials of persons charged with acts of terrorism should be conducted in civilian courts. Now, I can see the move that the desire to use evidence collected by militaries located in conflict zones as justifying the basis for the use of military courts. And I think that would be profoundly regrettable and really inconsistent with the very trenchant jurisprudence we have from both regional and international courts. So let me stop there, and I look forward to a robust exchange of views, and I'm really glad that we have the opportunity to have the conversation.
Thank you, Fionnuala, for this introduction and really setting the scene very clearly, I think, also clarifying the legal and normative framework. And again, thank you so much for our cooperation in setting up this webinar. You've mentioned a couple of instruments. Indeed, and David can speak more about the CTED guidelines, so I would now like to give him the floor to explain more about the scope of these guidelines. David, you have the floor. You're muted. Yes.
Yes, okay. So thank you, Fionnuala, and thank you, Christophe, for organizing this event. In a way, it's rather interesting that you are bringing me back to the crime scene, at least virtually, because it was in The Hague where it all started. And I'm glad that you mentioned Bibi van Ginkel. I don't know if she's with us today or not, but clearly it was Bibi and I who were the main culprits in bringing the issue of battlefield evidence, and we did it in The Hague. And what I would like to do in my remarks is not so much get into the content of the guidelines, but get you deeper into how they evolved, why we were working on them, why we decided to go ahead with this clearly controversial issue, and how to use the guidelines. And I think that for the participants here that are representing the member states or are officials in any duty and looking for guidance, the guidance are not manual, and it's really important to understand how they were developed and why, in order to be able to use them properly. So it all started indeed in 2014, and the reason it started in 2014 is that, as some of you know, CTAD has a mandate, among the mandate on assessment and monitoring, to identify trends, challenges, and issues in the implementation of Security Council resolutions. And back then we held a series of seminars for high-level prosecutors where we tried to understand what are the challenges they face. The series started in 2010, 11, and in one of the meetings held in 2013, prosecutors from different member states started raising with us the challenge of dealing with returning foreign terrorist fighters. They say, their people come back, but we do not have evidence against them, so we have to send them home. Other countries were talking about a large number of detainees where if not being indicted very soon, they will have to release them, still knowing that they pose a risk of committing other more attacks as they have done before. So we started looking more deeply on the issue, and clearly one of the issues that came up from those prosecutors was that one of the challenges they face is how and if to use battlefield evidence or evidence collected by the military. So we started looking at it and decided to convene, with the support of your partner organization, the Citadel Institute and the ICCT, towards convening a first meeting where we learned the practices of member states and tried to see what can be done about it. This started the whole 5 years intense discussions and consultations among several UN entities, among experts from member states that were happy to contribute to the discussion, that ended up in the development of those guidelines. Now, we faced back then a serious dilemma, and I think Fionella touched on some of the issues that were of concern, and mainly the issue of exceptionalism was one serious concern on whether we should go ahead with it. We know that it's very easy for guidelines to be used against their original intention, where countries may take some of it, but not all of it, may use the guidelines to legitimize acts that we never intended to do. So that was a huge risk. On the other hand, there were other risks that we could not have ignored, and I mentioned few of them. First, that suspected terrorist will go free without being indicted or prosecuted. Another risk is serious violations of human rights, and this was not hypothetical, because back then there were hundreds, if not more, people detained without rule of law guarantees, without an ability to challenge the allegations against them. And we had to choose: are we going to leave the issue as is, or we're going to tackle it and try to offer some guidance? We eventually took the harder approach, at least from the 5 years that it took us to elaborate these guidelines, and opted for developing the guidelines. And we constantly briefed the CTC about the challenges and the way we are going to approach them. And we think that eventually we offered some good advice to member states on how to deal with this issue. In the meantime, as we briefed the CTC, more and more about the development of those guidelines, the Security Council has seized of the matter. And as you know, Security Council Resolution 2396 made a specific call, and I would quote it, calls upon member states to share best practices and technical expertise with a view to improving the collection, handling, preservation, and sharing of relevant information and evidence, including information obtained in conflict zones. Now, it is not the first time that the Security Council issues a call, but does not detail what that call entails. That's part of how the Security Council operates. We have, and this is not the topic of the conversation, but I'm sure Fionela will remember that we have similar discussions on 4 words in the same resolution on the use of biometrics responsibly and properly. The Security Council doesn't say what is responsible use of biometrics. It just tells member states we need to do so responsibly. And that requires entities, member states, to start developing some tools for member states to implement the resolution. It's a Chapter 7 resolution after all. So that separate track made us even more convinced that we need to offer guidance, because there are then 2 options. First, that member states will just develop their own guidance on battlefield evidence without due regard to all the critical rule of law, IHL, and human rights law safeguards that need to be part of those guidelines, or that they will just not be able to implement it. It's very often the case that we at CITAD face this dilemma, where the Council issues, and again, it's not in any way a criticism of the Council, this is just how the Council works, issues guidance or requirements at 30,000 feet above ground level, and practitioners, UN entities need to start implementing it while respecting all the principles I mentioned before. That reinforced our belief that we have to take, and actually we were the first to complete that exercise and provide some guidance for member states. Now, when we developed that, we were very, very conscious of the risk. And I want all of you who are intending to read the guidelines, and I'm not going to go over them. I don't think we have time, and the guidelines are public and available, and I hope you can share a link to them in the chat box. But how to use them? There are many important caveats and disclaimers that we added, and were not just done for the purpose of feeling good about it. They are critically in implementing them. The first thing we mentioned that this was the first attempt at the international level to develop guidelines, and we do not see them, and we never saw them, as the last word on the matter. In fact, what we try to do is to open up the conversation on a thorny and difficult issue, hoping, and clearly we have succeeded beyond our expectations, to open a conversation on the issue so that others, member states, IROs, the human rights community, civil society will be able to chime in and offer their own guidance, their own emphasis, and perhaps even criticism of what we have done. And we hope and still hope that when the time comes, we will go back, collate all the relevant guidance that has been developed since we put the first paper out, and provide a further guidance or a more refined guidance. So this is an important element of the guidance that I encourage all those who are using it to develop, to look into it. We also highlighted in numerous occasions, and not just for the sake of saying it, with very specific detail, what are the human rights principles and IHL requirements that apply to each and every aspect of these guidelines. And then lastly, we narrowed the scope to counterterrorism, because we wanted to make sure that we are doing something in an area that we feel comfortable and not touch on other areas when there are plenty, and you mentioned, Christophe, at the beginning, where a battlefield or evidence used by the, collected by the military can be used. There may be other considerations for each and every area, but in the domain of counterterrorism, we felt comfortable that we can offer guidance. Now, clearly, another area that we highlighted that, and it's in the headline of these guidelines, these are aimed for civilian use. We were worried, and again, Fionella highlighted worried, they worried that once you start exceptionalism, you open the door for military courts. We were conscious of it, and we wanted to make sure out from the start that this is not our intention. In fact, what we hope that is if the guidelines are used properly, there will be much less need for use of military commissions or courts, because member states will know they have tools that are good enough to allow them to bring the cases to civilian courts with all the fair trial guarantees that civilian courts can offer. We also highlighted that the collection by the military should be perceived as the exception and should not be a part of a regular or conventional way of collecting evidence for this. As I said, we were very, very pleased that following our first paper on the topic, other entities like NATO, the Council of Europe, the US, Eurojust have developed their own guidelines. And we offer and continue to offer all those who wish to consult us on the process.
David has frozen there for a moment. Maybe he will come back. Let's wait a few seconds.
I think we may have lost him, Chris. Just he may have to rejoin.
Yeah, I think so too. I will. I suggest that we continue with the presentations, and then when David comes back, he can finish his story about the background and the scope. I actually did touch upon the scope of the guidelines. He's now removed from the screen, but that usually means that he will also come back. And I also saw that various questions have already been submitted, especially to Fionella, so that's good. I would like to reiterate again that you can send in your messages via the chat. And in the meantime, I've spoken so long that David has already joined us. So David, if you can unmute yourself, then you can
Okay,
finish.
I'm very sorry. It's,
no problem.
I don't know if I moved to my phone. It's not something that...
no problem.
Happy. I don't know where you lost me, but I'll just add that my last point was that if a reader for an official in any capacity wish to see in these guidelines a manual or something that can be easily translated into an SOP or even legislation, he might be disappointed because it is impossible to do so. The way we drafted the guideline is more at the level of framework than actual guidelines. And let me elaborate a little bit on this point, and I can give two quick examples. If you, for example, look on one guidance, the language says if the state wishes to see its military purposely engaged in the collection of evidence, it should consider included in the mandate of the military. You could see from the language two things. First, we do not necessarily encourage states, but we're saying if the state wishes to do so, this is what you have to do. If you plan to do it, states are encouraged to consider establishing procedures and mechanisms for turning classified intelligence into admissible evidence. So if you plan to do that, this is what you have to take into account: full respect of fair trial guarantees, equality of arms, etc., etc. What I'm saying is that the way we drafted the guidelines is mainly to invite member states to have internal interagency discussions and perhaps even with the legislator and look into the questions. And what we offer is first, what are the issues that you need to look at from the way the military operates all the way to enabling legislation? And in each and every area, if you plan to take this act, these are the issues you want to look at. But we didn't tell member states how exactly this is going to be. We provided the frame and said, listen, you have your own constitutional guarantees, you have your own cultural arrangements, you have also perhaps even the legislation relations between the military and civilian. We cannot be in a position to tell any member states how exactly to do that, but these are the issues that you need to take into account, and this is how we hope the guidelines can be used. I think I'll stop here. I'm sorry for the interruption in my connection. I hope you were able still to get the gist of my remarks. Thank you again, Christophe, Fionela, and the other representatives here. We really look forward to engaging in this conversation.
Thank you, David. And we got much more than just the gist. So thank you so much. It was really very clear, the background, but also, again, the scope of some of the rules of the guidelines, or I should say maybe the framework by CTAD. Then maybe let's move to our third speaker, Noam. He will speak about the Geneva Academy and ICRC guidelines on investigating violations of international humanitarian law. And the question is indeed, to what extent are these guidelines relevant for the topic of this webinar? And what are the international legal frameworks in place when it comes to the investigations on the battlefield, including the collection of evidence? So Noam, you have the floor.
Great, thank you very much. And especially thanks, Christophe and Fionnuala, for the invitation to speak at this event. Initially, when I received the invitation, I was thinking, wait, but what's the relevance? Why am I being asked here if it's about battlefield evidence for terrorism prosecutions? And the guidelines that I've been asked to speak about really are focused on ensuring that states have effective investigations into the conduct of their own forces, which is in a sense a different question. But the more I thought about it, the more I realized that there are some very important connections, both in the background that led us to the guidelines I'm going to speak about, and some of the substance of our guidelines, I think can provide perhaps some useful points and lessons for the topic today. So let me first just give a little bit of background about our guidelines, because I think it speaks to some of the problems generally with investigations, and then I'll draw from our guidelines themselves a few particular points without going through the guidelines in any great detail. The first thing to say, when we started looking at this idea of guidelines, a lot of this arose because there are really no explicit laws, rules, certainly not in hard law, and not in IHL for sure, on investigations, right? I mean, if you look in the Geneva Conventions, protocols, you have discussion of repressing grave breaches, suppressing other breaches. There's barely anything explicitly mentioning investigations or duty to investigate at all, right? And even in human rights law, it's sort of in the hard law, again, the focus is on trials, not, and those processes, but not so much, there's not as much on investigations themselves. There's a lot that comes through the case law, but that's different in terms of how it applies and how it applies universally, right? And so when we were coming at this certainly from the IHL perspective, we're thinking, okay, well, we need to maybe see what's out there and maybe provide some assistance on this. And again, the IHL human rights divide is one of the issues here, right? I won't get into detail about that, but if people are interested, maybe in the question and answer, I can come back to it, how we resolved it and how we got around sort of the problem there of sort of talking about militaries and whether we use human rights law or not. But initially, when looking at this, and this was at that point, when I held the role of Swiss chair of IHL at the Geneva Academy, we thought, oh, this is interesting to talk to a few people about, and we put together one of these sort of small, workshops, expert meeting kind of things to discuss it, and we thought we'd just have one meeting and put out a short paper, and that would be it, right? And we had the meeting, and honestly, I've never seen anything like this in all the expert meetings and workshops I've been at over the past couple of decades. I've never seen one in which, at the end of sort of a day and a half discussing a topic, everyone came out with a look of shock on their face. Right? We had senior people from IHL, human rights, practitioners, military, government, NGOs, and it was really interesting because everyone came into the meeting thinking, well, we know what we're supposed to do with investigations. And at the end of a day and a half of discussing it, everyone realized that no two people thought the same thing. There was no agreement on what actually, what type of incidents trigger an investigation. What does an investigation mean? How do you go about investigating? Who investigates? What are the rules that apply to investigations? Everyone had completely different practices and a different conception of what it is they were meant to do. So as a result of that, we decided to build a larger project. The Swiss government, the Federal Department of Foreign Affairs, kindly funded this. We had some support also from the governments of the Netherlands and France at some point. It was primarily the Swiss though. And this ended up being a almost 5-year project with expert meetings, at least one a year, held in Geneva, Hague, Paris, 25 or so people at each meeting from dozens of countries. We had people from every continent, from North America, South America, Europe, Sub-Saharan Africa, the Middle East, Asia, and so on. If you look at the guidelines, you'll see a sort of list of participants. We had high-level participants, military lawyers, from military prosecutors sort of on the ground through to the people at the rank of general and so on, and directors of legal services, senior government lawyers, deputy attorney general of one country, foreign office defense, UN people, ICRC people, human rights NGOs, academics. So lots of people participated over the years. In this, we had extensive background research into the subject of investigation. Again, years of this that was conducted primarily by Claire Simmons, who was a researcher based at Essex and was also then one of the co-authors of the guidelines. We had consultations with other people in between the meetings. And importantly, after a couple of years, sort of halfway through the process, the ICRC joined as formal partners. And this went from being an academic project to something that ended up being a formal ICRC paper and ICRC policy. And those who have worked with the ICRC know how rare that is, for something to start out as an academic project and then end up being an ICRC publication. And Jelena Page, a senior legal advisor at the ICRC, joined as a co-lead of the project together with me, and also was one of the co-authors of the guidelines. So at the end of this, we had the guidelines which were published in September 2019, and we had 16 guidelines. We made it clear that we called them sort of law, policy, and practice, because, as I said, if we wanted to just stick to the explicit existing law, there was very little. And so we had to have sort of a mixture of these, but we tried to aim high, but to be very clear, when we thought that something was a clear legal obligation, we used that language, and when it wasn't, we were a bit more careful in the language that we used. And similarly to what David was just saying about the project he was involved in, we also had to be careful here in terms of, you can't give a blueprint that's you expect to be a uniform process that all states must follow. There are differences among states. If you just think of common law, civil law differences, the differences that states have in terms of the structure of their military jurisdictions, military police, things are just so different from one country to another. But we had to nevertheless provide something which we thought, from our perspective, could be, for want of a better word, translated into any legal system. Right? So any state should be able to look at this and think how to make it fit their system. And I think generally speaking, we managed to achieve this. I won't go through the guidelines, as I mentioned, but just to say that they cover questions over the recording of military operations, actions at the scene of an incident, a reporting process within the military, dealing with external allegations, how do you assess allegations, questions of independence, impartiality, thoroughness, promptness, transparency. We also were very careful, and again, I won't get into this now. For our purpose, it was actually really important. But one of the things we looked at was the difference between criminal investigations and administrative investigations, and what that actually means. We highlighted the difference between investigations that are meant to lead to the accountability of individuals, as opposed to investigations into systemic issues and investigations into policy problems. And also the importance of looking at state responsibility and not just all the time at individual accountability. So those are some of the things that we covered in the guidelines. I think, Christophe, you'll be putting the link to the guidelines in the chat, right? And just to say the guidelines, the link there is to the sort of the original English version, but the guidelines are, if people want to search for them, available on the ICSE website in a number of other languages as well. So as I mentioned, the focus in the guidelines is on investigating violations by states' own forces. But some of the things that we had to deal with, I think, are very pertinent to the discussion here. So I'll just mention a few of these as an example, and again, we can come back to more in the Q&A. So normally, when you think about sort of investigating and collecting evidence that will be used in prosecutions, we're used to thinking about this as something that could also be done sort of after the fact. You return to the scene of the crime, you gather more information. But the battlefield is often a space in which the military operates temporarily, and it can sometimes be very hard to revisit after the event. There can also be questions of risk of being there even in the first place, never mind coming back later. And so a couple of things that we discussed in relation to the guidelines were centered very much around this problem. One of them is the issue of record keeping. Now, because allegations of violations and crimes sometimes only get raised much later, and especially in situations where you might not always have access to go back to the battlefield, it becomes crucial to ensure that as much information as possible is collected on an ongoing basis, regardless of looking for evidence on specific crimes. So our very first guideline dealt with this, and we were saying that military operations should be recorded at the earliest possible time. And we recognize, of course, that this can depend on the feasibility in the circumstances. Now, I want to be clear here, I'm not talking about recording an allegation or recording something related to a particular incident, but I'm talking about the records and information pertaining to day-to-day military operations. Right? Even when it seems at the time that there's no crime, no violation going on. And when we had this discussion in our process, there was a lot, initially there was some resistance, and there was a lot of discussion around this point, more than we envisaged. We thought, this will be straightforward, we'll put this in the guidelines and move on. We ended up spending, at least one full day with our experts just talking about keeping records. And again, part of the problem is that you won't find anywhere in the law an obligation on militaries to keep records. There won't be anything specific about that in terms of their day-to-day operations. But ultimately, it was agreed by most of the people involved that if you don't retain records of operations, it can be impossible to have an investigation afterwards if any allegations arise after the fact. Right? And so at the end of the day, we did agree that you need to have records. And what do we mean by records? So people that are familiar with military operations here will know some of the things I'm going to give as examples now. Post-mission debriefs or after-action reviews, contact reports, mission reports, data that's accumulated by operation centers, detention logs, strike logs, right, targeting packages, rules of engagement. So all of these are just examples of the types of records that militaries generally have anyway. So this was important. We weren't asking militaries to do anything that they don't do anyway. We're just saying, listen, you actually need to make sure you keep these, that you retain this information, and store it in a way that can be retrieved later, if necessary, for investigations. Right, so this was one point that was very important for us, and I think is relevant here as well. The other problem with access to the battlefield means that we can't always use the same expertise we might have in other circumstances. Right, so I'm sure lots of people remember TV shows of, was it CSI? And we had CSI Miami and CSI New York, and the original I think was in Las Vegas, but we don't really have a CSI Kandahar. That operates alongside the military, right? And so, what do we do in that respect? Now, obviously, wherever possible, you should have specialized units. In some states, it will be military police. In others, it's the civilian police that can work alongside the military, who have professional expertise collecting the necessary evidence. But that's not always possible in a battle zone. Especially if it's a dynamic situation where you can't cordon off the scene of a crime. There might be continuing military operations, and you might not be able to return later. And even if you can return later, the effects of the operations will have damaged any of the evidence that you sought to collect in the first place. And so for us, this meant that military forces need to be given training in collecting and securing evidence as soon as possible when they become aware of an alleged violation. Right. Now, again, this can be difficult because, if, for example, it's one of your own soldiers that you think has just committed a crime, you can't always, if the battle's still raging, you can't suddenly take the gun away from the soldier and put it in a bag. Right. Things can get complicated in that sense, but that doesn't mean you can't do anything. And there are forms of physical evidence that can be collected. Fragments from munitions, for example, there are all sorts of things that you can do, but also commanders should be trained and know what it is they can do. And, nowadays, lots of troops operate with, for example, whether it's cameras, videos, or others. So record, audio, video. If you can draw, great, but take note of what just happened as soon as you can. Take note of everyone that was present, all possible witnesses, victims, perpetrators. Keep note of all of that. And I must say that since the guidelines came out, I've had lots of sessions with different military and justice systems around the world on the guidelines. And this is one of the areas where, at least my impression, is one of the areas that there is the greatest need to improve military practice. A lot of things in the guidelines, most militaries were saying, yeah, we kind of do that. Yeah, we can make it better, we can kind of. But this question of what commanders are supposed to do at the scene of a crime, I think is one of the areas that there's not enough being done right now by most militaries. And the training that they get here is relatively rudimentary, and it doesn't go down low enough through the ranks. It stays often with the higher commanders who aren't the ones often on the field. So this is one area that I think there can be some improvement. And one of the discussions to have here, because we focused on the question of violations by own forces, but should we also be training militaries for the reasons I just gave to collect evidence regarding crimes by other actors on the battlefield? And I think it's a difficult question, and for some of the reasons that that have already been mentioned by other speakers. At the same time, if it's possible that the military will be the only people there, or at least the only people there while the evidence is still accessible, then I think it's something that we probably do need to look at in more detail. Another issue that came up in the guidelines, and I think is relevant here, is about external allegations and what do you do about that. Right? So often it's external sources, individuals, journalists, NGOs, that are the ones that will alert us to possible violations, whether by the military or by other actors. We need to know how to deal with those, and there needs to be some agreement on this as well. So militaries need to have accessible and effective processes for receiving external allegations. That means that information needs to be made available to the general public about these processes, these mechanisms, how you access them, who you go to if you have an allegation, how do you follow up on an allegation. And at the same time, within states, there needs to be an understanding of how you deal with allegations. Now, sometimes there might be a need to prioritize, but then there need to be clear guidelines, how you prioritize, on what basis do you prioritize, how do you identify sometimes when there's patterns of repetition of certain types of allegations that might, again, point to something. What do we do about vetting them for credibility? Lots of states and more generally, you hear discussion of, this is ridiculous. We keep getting these preposterous, in the UK, vexatious is a word that you hear, claims, and it's impossible, and it doesn't make sense, and there's too much, and so on. And so there's a question of vetting for credibility. It's something that we looked at in the guidelines. What does that mean, credibility of allegations? And we pointed out that determining credibility of an allegation is not the same. The standard that you're looking for is not reasonable grounds. You're not looking to determine whether there has already been a crime. You're only determining the credibility of the allegation itself. So if you hear the allegation is that something happened in a certain place on a certain date, you're not trying at this stage to determine whether that was criminal or not. You just want to know, does it make sense that these actors were there at that time and violence was used? That's enough, right? That's enough to make you look at it more and potentially open an investigation. The last point I'll raise for now is just on transparency. And again, this is something that is true whether we're dealing with investigations into state-owned forces or into other actors. There's a huge problem with transparency when you're dealing with investigations, particularly if they're conducted by the military. And a big problem is if a lot of the information that you've got rests on military records. I just mentioned the importance of keeping records, but those records, strike logs, targeting packages and so on, rules of engagement, all of this, the military could consider, the type of stuff that they don't want to make public. They don't necessarily even want to give to courts. Right? So what do we do with this if a lot of our evidence is evidence that is of that nature? And there's a very real risk of, and we again recognize this in the guidelines, of over-classifying information in armed conflict on national security grounds. So on the one hand, we recognize that there can be a need sometimes to classify information. It's not a something that is unheard of, but we pointed out that that it's good practice to have an appropriate process that can review classification decisions themselves. More generally, that there has to be a possibility to challenge classification, particularly in criminal proceedings, and that the review process needs to allow for an independent assessment of national security concerns to avoid problems in this regard. So the points I just made, I think, as I said, they come from our guidelines, which relate to something slightly different, but I think they're all relevant to the topic being discussed here. There's other stuff I could have come back to around, independence and other issues that arose, but again, perhaps in the Q&A, if people want, I'll leave it there for now. Thank you.
Thank you, Noam. Very clear presentation again. And as we speak, questions are coming in via the chat. We have many, so I already will apologize now that we probably only can select a few later in the Q&A. But let's move now from the battlefield that Noam described and the challenges mentioned there, maybe to the courts and to the fair trial issues there. So Maya, can I give you the floor? Thank you.
Oh, absolutely. Thank you. Thank you very much, Christophe and Fionnuala and the mandate for this invitation, and also fascinating to hear the remarks of Noam and David, and of course, Fionnuala. So I would like to focus in the time that I have here on the situation that is facing men, women and children in northeast Syria, in camps and prisons there in the context of the war against Daesh. And this is an area, as you mentioned, where Reprieve's been very active. We have a large number of clients in the camp, some of whom are victims of trafficking. There are, of course, children there too. We're very concerned by the discussion of battlefield evidence in this particular context, and work also with other NGOs, including Fair Trials International, Amnesty, International Commission of Jurists, Privacy International, and have written to the Council of Europe's Committee on Counterterrorism regarding a draft recommendation on battlefield evidence to raise some of our concerns about this. And we've not received a response on that, which perhaps we can come back to in terms of process around these emerging norms and soft law practices and consultation issues there, perhaps in the questions later. Just as backdrop, Reprieve is advocating for the repatriation of foreign nationals from the camps and prisons in northeast Syria for prosecution where appropriate. And before I get into the specific concerns with battlefield evidence, a snapshot for those who don't know of the situation that our clients find themselves in Syria. There are almost 70,000 women and children in Al-Hol and Raj detention camps in northeast Syria. The women and children, many of whom, as I've mentioned, are victims of trafficking, are being held in dire conditions, inadequate housing, freezing temperatures, lack of running water, mass violence, shocking levels of child mortality. And indeed, the UK Special Immigration Appeals Commission and Court of Appeal have acknowledged that the conditions in both Raj and Hol were sufficiently desperate that they met the threshold of inhuman or degrading treatment for the purposes of Article 3. Of the ECHR. And that's relevant, I think, to some of the discussion of battlefield evidence, and I'll get onto that in a moment. But the camps and prisons in northeast Syria have rightly, I think, been likened, including by the US administration, to a kind of European Guantanamo. And that's not simply because of the appalling conditions, but also because they are held effectively in what is now a legal black hole, with no prospect of charge or trial for the thousands of detainees, and the majority of whom are children who are held there. So in this context, the discussion of battlefield evidence has arisen as presented as a kind of solution to some of the challenges that are posed by prosecuting crimes committed by ISIS. And whilst I am not by any stretch undermining or diminishing the difficulty of prosecuting some of these crimes and the complexity of it, we are concerned by a narrative that suggests that this is now an exceptional circumstance which requires a dilution of fair trial rights or a loosening on the rules of admissibility of evidence, in particular, in this context, by the admission of battlefield evidence, which would otherwise not normally be admissible in criminal proceedings. And in some areas, and I'll talk specifically about the UK context, this seems to us to be disingenuous and dangerous and potentially a very deliberate distraction from other core issues that need to be resolved. So, in the UK, for example, there has been a lot of public and indeed notably political discussion of the challenges relating to prosecuting ISIS crimes. And that has been used as a justification for not repatriating the British families who are currently detained in northeast Syria. But in our experience, and experts have noted very regularly that it is eminently possible to bring these families back, and that in the majority of cases, alleged foreign fighters will be prosecuted successfully. And I won't go back over the points that Fionnuala mentioned about the ordinary criminal law being equipped to deal with terrorist prosecutions, but I will simply say that these are taking place in a number of states which have repatriated their nationals from northeast Syria. In the UK context, just to cite a couple of examples, former Director of Public Prosecutions, Ken MacDonald QC, has said there are a range of crimes, ordinary crimes, for which it would be possible to prosecute individuals with what he describes as a mountain of evidence that might be used in any trial. The current Director of Public Prosecutions has further said that in the vast majority of cases, returning foreign fighters will be prosecuted, noting there are several different terrorism statutes for which individuals can be convicted, preparation of terrorist acts under Section 5 of the Terrorism Act, as he's described as one of the charges of choice for prosecutors. And as to the evidence available for use in prosecutions at this moment in time, the current independent reviewer of terrorism legislation, Jonathan Hall QC, has further said that vital material can be acquired entirely away from any battlefield, such as, of course, materials left on or before departure from the United Kingdom. Obviously, each case turns on its specific fact, but in the UK context, as I mentioned, we have been troubled by what seems to be an increase in political rhetoric about the difficulties, if not the impossibility, quote, of effectively prosecuting terrorist offences using our existing legal frameworks, which includes upholding standards for normal fair trial standards for admission of evidence. And this rhetoric in the last few years has been shown repeatedly to have been calculated, cynical, disingenuous. And one example that I'll give on that is the resistance by the UK to bringing back some of the very notorious alleged IS fighters who were known as the Beatles, Alexander Coty and Shafi al-Sheikh. In this case, the UK government claimed that they couldn't successfully prosecute these individuals in the UK because the authorities, quote, did not have the evidence to try them in this country. And they pushed for the transfer for prosecution in the US. During the Supreme Court hearings on this case, it was a different issue that was being dealt with. What was revealed was that the UK's Crown Prosecution Service had, in fact, authorised charges to be brought against one of the men for his involvement, years back, for his involvement in 5 counts of murder and 8 counts of hostage taking, meaning, of course, that they had sufficient evidence to authorise charges for really, really serious crimes without needing to change the evidentiary standards or indeed send them into another jurisdiction for prosecution. It also emerged in that same Supreme Court hearing that the Director of Public Prosecutions had conceded there was sufficient evidence to charge the other individual as well. I think the fact that the UK government had sought to withhold that information sort of shows the position and the posture that we have here, where political agendas, as is often the case in the counterterrorism context, are being used and are allowed sometimes to have undue influence over legal processes. And I think it's our, as human rights NGOs working in this space, our job to flag where we think that there is some of these safeguards are being run roughshod over. In terms of the battlefield evidence issue here, we have serious concerns that the introduction and attendant dilution of fair trial standards is unnecessary and also a slippery slope that would carry potentially grave harms for our clients. In particular, I've mentioned the conditions that they're held in. We are worried that there may be a lack of safeguards to prevent evidence being admitted that derives from torture or was extracted from individuals who were held in conditions that amount to CIDT. For example, within the Council of Europe's draft recommendation on battlefield evidence, there's a broad reference to the prohibition against torture under Article 3 of the European Convention, but to our knowledge, no specific safeguards embedded that would prevent the use of torture evidence. And we're concerned that it would, in reality, create a permissive environment for the abrogation of the right. Additionally, from my visits and our visits to the camps and conversations with individuals who are detained there, it's very clear to us that these individuals are not able to speak freely, that they are subject to intimidation, threats, harassment, CIDT, and other retaliation for comments they make. And in such circumstances, it's very clear that interrogations taking place in the camps couldn't comply with the same due process safeguards that are used by domestic law enforcement. And there is a risk that being conducted in these circumstances would amount to a breach of their right to not be subjected to torture or CIDT. Additionally, we have concerns as to how the evidence would be shared and used to pursue prosecutions in third countries, including those where torture and death penalty are common. For example, within, again, the Council of Europe's draft recommendation on the use of battlefield evidence, there aren't safeguards that we've seen against the prospect of this evidence being used to impose death sentences in states outside of the Council of Europe. And we know, of course, that Iraq has already sentenced scores of people to death, including at least 8 European citizens following 10-minute trials tainted by allegations of serious and sustained torture. And the introduction of battlefield evidence to support these kinds of deeply unfair trial processes risks entrenching injustice in this area, which would legitimize prosecutions potentially based on unreliable evidence and further undermining the rule of law. We are also concerned, and this is my penultimate point, that the suggestion that battlefield evidence could include information collated by military personnel, intelligence services, and private actors such as journalists, and I'll talk about journalists a bit more here, that would then be rendered admissible as evidence. And we think that this could lead to seriously unsafe convictions based on faulty, unreliable evidence. Again, in the context of the women who are our clients in Northeast Syria, we have observed that there is already a really dangerous and disturbing trend whereby evidence from third parties, including notably journalists and members of the press, is being admitted into legal proceedings that are brought against people accused of terrorist offences. In the context of citizenship stripping here in the UK, for example, we have seen the government relying really heavily on generic and also specific media articles about our clients and our client base to build a case against individuals whom they've stripped of citizenship. Now, these individuals have been held in camps in dire conditions for years, some of them, and they are denied meaningful access to counsel. They are subject to the pressures and intimidation that I've described. They are unable to communicate freely with anyone outside of the camp. Their conversations are monitored at all times. They are at risk of serious repercussions for what they do say and also what they omit to say, and understandably live therefore in a climate of some fear. And in that context, I think it's clear that any communication with a journalist or indeed others who may gain access, and I should repeat that lawyers really struggle to get access to these individuals, as indeed do human rights activists, NGOs, etc., and to speak freely with them. So any communication that they do have can't be considered, in our view, free and informed, and using material that derives from conversations with detainees or from individual observations or personal commentary from journalists about their views of these detainees, it would be very troubling to use that in criminal prosecutions or as evidence to justify citizenship stripping. And I think that poses really serious concerns about fair trial standards and the rule of law. This is troubling, of course, from a human rights perspective to us, to Defence Counsel, and of course to the detainees themselves. It's also quite disturbing, I think, to the media, who have made clear they don't want to be co-opted and brought in to play a sort of prosecutorial part, which they do not feel they are equipped to do. And I'll just cite the recent case, which no doubt many of you know, of Shamima Begum, who was the 15-year-old schoolgirl who travelled to Syria. The Metropolitan Police had applied for orders to force the BBC, ITN, various news media to hand over notes and footage from interviews with Shamima Begum in the camps. And it was joint legal opposition from these various media outlets who resisted the application that then they ultimately prevailed. They had to argue, or they did argue, that the order would deprive journalists, I quote, of their neutrality and place them at risk by making them de facto actors of the state. So I think that's a troubling development. I think we're getting close to time here, so I won't speak more about the Supreme Court case in Shamima Begum's case, but it is a case that really shows the vulnerability of the people who are held in those camps and the sort of cynicism of the marriage of a political agenda and a very permissive or problematic hybrid, as Fionnuala described it, closed and open court system where you have evidence being used against individuals who are not able, and the Supreme Court did acknowledge that these individuals, including Shamima Begum, are not able to present a defence from where they are, yet there is information used to prosecute them, to strip them of their citizenship, and they are unable to effectively defend against that. And we, as people representing them, are unable also to mount a meaningful defence. And so in terms of equality of arms, I think it's very clear that that is very much stacked against the individuals. All of this is all the more concerning in the context of the specific cases that we know about. Many of our clients were children when they travelled or were taken to Syria. Many, as I say, fit the definition of trafficking. They have endured years of trauma and abuse. And in those circumstances, I would say there's a need for much more care and attention to be paid to the process of really careful, meticulous evidence gathering, not less. And safeguards are, of course, critical to ensure not only successful prosecutions and accountability for the crimes committed by ISIS, which of course we support fully, but also to ensure that we are effectively upholding the rights of those who may be victims in all of this. And I think that close there, that I couldn't have put what Fionnuala said better in terms of the intersection between human rights and the need to, security and human rights in this context. Thank you.
Thank you, Maya, for sharing all these concerns and insights. I'm a bit wary of the time, so I first would like to give our panelists the opportunity to also respond to each other before we go to the Q&A with the general audience. So are there any of the panelists who would like to respond to the presentations that they've heard first? Fionnuala, I see your mic is open.
I mean, I guess I would say that I do want to frame the broader regulatory framework, maybe just in dialogue with David about the role of the Security Council in all of this. And so David is right, and it's perhaps easier for a special rapporteur to say this, but we have an effective situation in which the Security Council is acting as a criminal law regulator in the area of counterterrorism, with massive consequence at the national level in multiple ways. And I think that's an impingement on sovereignty. Actually, I would make some arguments that while, of course, there are significant and unfettered powers in the Charter for the Council in this regard, the impact on the balances that are struck at national level, particularly in the area of criminal law, and the idea of the deprivation of liberty as one of the most fundamental things that you could take away from the individual. It does concern me that that role is being played. I guess I would also underscore the extent to which that's a human rights light space. So it's certainly true that some of these issues that have been identified by the Council as important, they're thus identified, including battlefield evidence, but my concern, the pattern here is that what we see is an identification of issue without the attendant attention to the human rights and rule of law implications of those things at the national level, bearing in mind that across the globe, many of the countries in which this kind of implementation will happen are countries with serious human rights violations, countries with systematic deficits in their national legal systems. So at the abstract, we say, yes, we can do this, we can see this regulation being done, but it's done by actual militaries with actual histories of systematic human rights harms, I think, is the work that Noam and Jelena and others identified. One of the challenges here is the consistency of military practices and the upholding of standards. So I think that's where the mandate's sort of broader, and that's outside of the range of this discussion, but it does sit in the universe of who's regulating and what's happening to national law. And I'm an old-fashioned international lawyer. I do think that domestic legal systems have some rights to regulate their particularly their criminal justice systems in ways that that should be given some leeway.
Thank you, Fionnuala. David, would you like to respond? Yes, please.
When I mentioned the biometric responsible use of biometric, I knew that Fionnuala will jump, and we will have to import here a whole separate discussion that we have, which touches on the same issues. What is and what the Council needs to do in urgent times. And look, 2014 was not when we started working on battlefield, was not a regular year. This was the year that ISIL took Mosul. This was the year when the world witnessed thousands of people leaving everything they do in life and joining the ISIL battle, where it was about to take over Iraq, 80 kilometers from Baghdad, it stopped. We've seen the thousands of people leaving. We have seen the heinous crimes that we also public executions and all the crimes committed against the Yazidi communities, and the world needed to react and react fast. And the only tool the international community has in such times to react fast and decisively is the Security Council. Now, I agree it may be imperfect. Ideally, we would like to have 5 years of negotiations over a convention on battlefield evidence, or convention on biometrics, or convention on any other issue that we would like the international community to take. But reality doesn't wait 5 years. And in the meantime, we need member states to stop the travel immediately, and we need them to be able to bring to justice those perpetrators. So we have here a choice between hard choices. I mean, there is a whole famous book called Tragic Choices, which is exactly that. It's not one good choice and one bad choice, but opting for what is the least worst option. And this is how we approach issues. And that same principle applies to whether we should develop guidelines or not. Should we leave it with the risks that the Security Council resolution will be overused or misused or sometimes even abused? And we know, and Fionnuala has been covering those abuses intensively, and Maya shared with us some of the potential misuses of those principles. These are inherent risks, but the choice is to have or not to have some guidance. Maya, one second point from my side. You touched on two issues which I think are critical to the conversation today, and these are the issue of repatriation and the issues of justice with available evidence. If done properly, I would argue that military evidence can be a tool for effective repatriation. I know that the international human rights community raised on numerous occasions the importance of repatriation. I think you even, Fiona, named it as a human rights obligation. But not all those will come back to their countries are innocent. Some of them, perhaps not all of them, committed heinous crimes. So the question is, can we support member states in their decisions to repatriate by telling them repatriating doesn't mean that you send necessarily that person to the street. You will have tools and robust tools to bring that person to justice. So in a way, I see military evidence as a possible vehicle for effective repatriation of individuals. Second, that would be my last point on the availability of evidence. I'm not in a position to criticize the UK government. I think it's one of the most respected legal traditions, the mother of all the common law systems for, I think, 1,000 years. I'm sure the courts in the UK are providing a review of every piece of evidence that is brought against suspects. I am a bit hesitant to say that there is enough evidence out there so that we do not need battlefield evidence, because sometimes, and this is what we're seeing in very often in many countries, there is evidence, but that evidence does not reflect the crime. It could be evidence on supporting, evidence on even traveling, but that will not bring justice to victims. If somebody was raped or somebody's family member was murdered, as prosecutors, I'm not a prosecutor, but as a state that wants to bring justice to victims, and victims' rights are also human rights, you have to make sure that whatever this person is brought to justice for reflects the seriousness of the crime. So if that person enslaved individuals, murdered individuals, or trafficked individuals, you want the state to be able, for the victims, to bring that person to justice for what he or she has done, and not on peripheral offenses that can always be used, but do not reflect clear justice for the victims. I think I'll stop here. Thank you.
Thank you, David. Noam and Maya, would you like to respond? Not necessarily to this point, but in general. I see Noam raising his hand.
Yeah, just a couple of quick points. One is just in relation to the exchange just now between Finola and David. I just couldn't help myself, and I'm speaking here almost as an external observer, but so the discussion about the need to respond because of events, 2014, 15, and so on. And I just suddenly, I had a flashback to September 2001, and the need to respond, and the responses that came through the Security Council to 9/11, and some of the huge problems that arose in relation to human rights, back then, and sort of the quick focus on counterterrorism, and perhaps a sudden neglect back then of human rights issues. I remember my late friend and mentor, Sir Nigel Rodley, when he was Special Rapporteur on Torture and then the Human Rights Committee, and him going off to New York to try and plead for, remember human rights in all of this, work that's being done on counterterrorism. And so I'm just thinking, there's always this danger when there's a perceived need to respond quickly for security reasons that needs to be borne out. I do think that the responses now coming through the Counterterrorism Committee, and much of this is also the work of David, is a lot better from a human rights perspective than it was, back in the post 9/11 days. That's not to say it's, obviously from a human rights perspective, there's always more to improve. But it's not like it was. But I get nervous when we talk about sort of the need to quickly respond from a security perspective. The other point I want to make, and this is something that ran through some of the presentations, and I think it's in some of the questions as well, is it's really interesting to see in the discourse how we think about sort of military versus civilian systems. right? And in a lot of the, whether it's the different guidelines that have come out, the discussions that are happening around them, there's often an assumption that the military processes will be worse from a professional, human rights compliant and so on perspective, and that civilian is always better. And it's interesting because in the research that we were doing for my project, I'd say that's not always the case. It really depends which country you're talking about. In some situations, actually, you'll get a much more reliable, professional, and in a sense, human rights compliant process through the military than you can expect in the civilian system. And it's just something to be aware of. I mentioned the researcher that worked with us, Claire Simmons. She's working right now on a PhD in the final year on independence of military investigations, and some really interesting stuff she's uncovering there. I think watch out for, I don't know, Claire, if you're here and you're watching this, but I'm now putting some pressure. Watch out for when Claire finishes and publishes, because I think there'll be some really interesting stuff coming out there when you're talking about what we expect and what we think military processes are. And I think we need to be careful with regard to assumptions that we sometimes make in this discourse.
Thanks, Noam. Maya, any final observation from your side before we go to the general Q&A?
Well, on the case of the prosecutions in the UK, I too, of course, the courts are excellent, and I think it's my comment was really on the politics of it, and where we are having a rhetoric that doesn't match the reality of what's possible. So with the Beatles case, it would have been possible to prosecute for really serious crimes in the UK. So we're talking 5 counts of murder, 8 counts of hostage taking. I worked with some of the victims in that case. They wanted justice and accountability. That could have happened much, much sooner. The UK was in possession of a ton of evidence, and they took a case, or a case had to go to the Supreme Court before, because they didn't want to prosecute in the UK when they had eminent capacity to do so. So it's really that I think is concerning in this domain for me.
Okay, thank you very much. I said a few minutes ago that I'm wary of the time. Now I know that we're just simply running late. So I will just select a very few questions. Many came in, so hopefully we'll be able to get back to you on the questions that we could not answer. Maybe the first to Fionnuala from BB von Ginkel. She was already mentioned at the beginning. She asked, recently there are a couple of court cases that resulted in convictions based on evidence gathered on the battlefield. Do you feel that serious violations of human rights were committed during these trials and fair trial principles were violated? And then maybe as a follow-up question that I thought was quite interesting from Ingrid Elliott, she wonders if military actors are collecting battlefield evidence, what can be done to ensure their response and interaction with sexual violence survivors are safe, effective and ethical and survivor-centric? So maybe those two questions for Fionnuala.
Yeah, so I guess I would say I don't want to comment on individual cases per se that the mandate hasn't spoken on publicly, just to be fair, but I will say that I'll just make a couple of general points. One is that the point is not in any individual case. You could say, well, this piece of evidence, and in none of those cases, let's be clear, was the battlefield evidence itself the primary evidence before the court. There were multiple pieces of evidence before the court. So I think that's a somewhat different framework than the reality that in many of the cases or the proposed views, you see a scenario in which this is the only evidence that's being used before the court. And that, I think, dramatically changes the calculus of both fairness, of the integrity of the evidence, of the fairness of the process in terms of equality of arms. I also think we've got to be really clear that it depends on the court, it depends on the legal system, and it depends on the rule of law. And so you're creating a generic rule potentially for widespread use across legal systems, plural, which many of those legal systems having inherent deficits already in relation to fairness of trial and process. And so the point here is really the broader point about the permissibility, bearing in mind two things: that when you create exceptional legal systems, they never stay exceptional. They move constantly. That's the rule. I mean, I think all of us would acknowledge that. So the idea that this is containable to that set of maybe exceptional cases, I wish it were true, but I think we all know historically that it is not. And therefore, the long-term risk is that, you know, bad cases make bad law. That's my old adage from legal systems in general. And I think it's one that we have to really be bearing in mind in this context. On the second question around victims of sexual violence, I think that the challenging part here, of course, is again, assessing whether or not security actors, in the absence of adequate training and capacity, are the ones to be carrying out this kind of evidence gathering. And I noticed that Max Marcus made a comment, one of our most well-known investigators and prosecutors of sexual violence crimes. And Max, I think, comment in the chat really underscores the point that there's already an enormous degree of knowledge with national prosecutors on investigating complex crimes. We do that all the time, actually. And so she makes the case from the place of having investigated these kinds of crimes, is not to view these things as silos and not to overindulge, in some sense, the idea of going to the exceptional, that over the long haul, what works best, it's going to sound old-fashioned, are old-fashioned rules and systems that are consistently implemented and where the rules are fair and clear. And fair trial is in the interest of the victim. An unfair trial does not serve the interests of the victim well. And I think that's been my clear point as Special Rapporteur, is prosecutions are exceptionally required here. But let's be clear, we haven't seen any. I mean, think of the Yazidis. We're not seeing prosecutions. And trials that are less than adequate will not redeem the rights of those victims adequately. And I think we would press for fair trial, not just for the sort of abstract fairness of trial, but because a fair trial redeems the interests of the victim in the best way possible.
Thank you. Maybe following up on this point of Maxine, she indeed also said that I just wanted to also encourage and invite you to integrate our fields of practice as much as possible. And this to me evoked a question maybe between the interaction of all these instruments that deal with this topic on battlefield evidence or military evidence. David, the CETAT guidelines are a little bit a trendsetter in this respect. Do you see any risk also of fragmentation of the various norms that are now being published by these different entities? What is your view on that?
I would say that from the start, when we put out these guidelines, we saw this as opening the discourse. We knew it's a thorny issue, but we thought, let's talk about it. We never thought that this would be the last word on the matter, and it's if you read the documents in the first page in Control B, Control U, you'll see this is only the first word, and it's aimed to open up the conversation so that others can develop their own guidelines and that collectively we learn from each other on how to deal with this difficult issue. If the UN at some point will be able to go back and develop a conclusive norm on the subject, maybe, I hope so. I hope that in the meantime, everyone who is in the field or is interested, or every practitioner or policymaker will be able to learn from the different guidelines that are out there, what is appropriate. I also hope that these conversations and the warnings and repeated warnings from our human rights colleagues will be taken on board when member states look at it and say, this is a difficult issue. Okay, if we are to go, please let's make sure that whatever we develop will not be abused, will be respectful and promoter of human rights and rule of law. And we are there to support this process. I mean, it's not that we're going anywhere. CETAT is here. The human rights community, the Special Rapporteur, I'm sure they will be happy to provide further guidance. We work closely with all the partners you mentioned and provide them our own experience, but we certainly do not see this as the last word. We only started the debate, and I'm glad that it's happening in the open so that everyone who is involved can take up all the issues on board when they think about it at the national level. Thank you.
Thank you, David. Then maybe one question from Maya from Victoria Rielo. She talks about the local prosecutions in Northeast Syria, and she wonders, from your context with the situation, is it likely that these authorities can uphold minimum fair trial guarantees if you talk about local prosecutions? What is your view on that?
Yeah, I think it's a really tricky question because of the territory they're in. You know, it's not a recognized state, so I think it would be difficult to, setting aside fair trial concerns, but specifically where, you know, jurisdictionally, I think it's quite problematic and complex. So if there have been lots of discussions, let's say people got sentenced to a few years and then were released, how is that viewed? How is that sentence viewed in a third country? Is it recognized? I think possibly not. There are lots of reasons geopolitically why it would be hard to establish local courts in Northeast Syria, specifically under the Kurds. Having said that, I think that there is work being done that is interesting and important on rehabilitation and various things happening there at the same time.
Okay, thank you very much. And then maybe the final question from Noam, and actually this one was addressed to Fionnuala, but I think it's also relevant for Noam. And the question was, you mentioned that the evidence would have to be collected by independent and trained investigators. How realistic would this be given the hazardous nature of battlefields? Noam, I think you may also have a view on this.
Yeah, I'm not sure. I think this question might have come in earlier on before I gave my presentation, because to a certain extent, I'm not sure I have much to add to what I said earlier, simply that absolutely, whenever possible, evidence needs to be collected by people who are best trained and qualified and able to do so. And in most militaries, this is recognized. The challenge, of course, is in those situations where it's simply not possible, right? So, you know, there's two sides to this. One, whenever possible, do so. I think one of the differences here is if you look across the board, the differences between states, you'll find that some states, in terms of investigations and collections of evidence, it's done by military police, and in others it's done by civilian police, right? When it's done by military police, that's not always the same thing. You know, sometimes the military police is actually part of the military. In others, it's called the military police, but it's a different branch that answers to the Ministry of Defense. And in others, the military police belongs to a different branch of government. Right? So you've got completely different conceptions, and we have to be careful when we say a word whether it means something. But point is, you know, most of the time, most states recognize that they need to have, and they do have, people who are specialized in this. But absolutely, there are many situations where it's simply not going to be possible, and you might never be able to get back to the battlefield. You're only there that once and under hazardous conditions. And this is why I was saying that we have to have better training in place for the military. It might not be perfect. It might not be what we want. It might not be ideal later. It might cause all sorts of problems. But if they're going to be the only people there that ever have access to it, we need to have better training for militaries in terms of how they collect evidence and what they do with it.
Thank you very much. Yeah, in view of the time, I really would like to conclude now. I would like to thank all of you for your questions and very elaborate answers. I think that's been a very interesting event. I would like to thank all the panelists for their insights, the mandate of the United Nations Special Rapporteur, not only Professor Fionnuala Lloyd, but also Dr. Anne Chabot for excellent cooperation, the events and communication teams at the Usher Institute for the hard work on the background, as well as you, of course, the audience, for joining and for your questions. We could not address all of them. We really have received many, also many comments, but feel free to send us an email and we'll try to follow up with the panelists. And also, if you want to rewatch certain parts, this webinar has been recorded and will also be placed on the USR website and its YouTube channel. I think the event has really shown you that there are various challenges and risks to this topic, but I'm also very happy that we have explained from various perspectives the legal and normative framework. And let's continue this discussion. As David mentioned, the CTED guidelines were the first discussion, and let's continue on this topic. Finally, if you're interested also in the legal aspects of countering terrorism more generally, I would like to refer you to the ASSA website for our 2 summer programs taking place in June and end of August, and our new masterclass, which will take place on the 15 and 16 November, also in this area. So thank you again to all of you, and see you next time at our webinars. Thank you.
Thank you.
Thank you, everyone.
Thank you. Thank you.